In this session, we'll be primarily looking at the various aspects of regulation, starting with what are the different types of regulations that are available, to who all could become the regulators, and then what are the various theories and interdependencies that are present with respect to regulations, and even talking about what are the various tools in terms of regulations, and finally looking at the cost versus the benefit analysis of getting into the regulations for various industries as well as companies. Right, so this is purely an economical aspect of regulation that we are going to look at in this particular session. So, whenever we are using the word regulation, we generally classify that into three major aspects. The regulations could be in the form of statutes, which are generally a kind of acts and all prepared by the legislative body of the country. They are one type of regulations. They are in the form of statutes. They have to be adhered by various entities. Then we have administrative kind of regulations, which are kind of rules set by either government agencies or some independent bodies which are authorized by the government. These are kind of administrative regulations. And finally, we have a judicial law kind of regulation where we see the court findings coming up. So, regulations could be in either of these three forms. And on the same lines, when we talk about regulators, there could be government agencies, but to a large extent, we can even have independent regulators, which are non-government agencies, but the government agencies, it recognizes and gives power to these independent regulators, but the only thing is they are not funded by the government. So they are politically dependent because they are not funded by the government. There is a possibility that they are more and more biased politically, or they have pressures politically. But when it comes to the independent regulators, we see two major groups. One could be self-regulatory organizations, whereas the others could be non-self-regulatory. When I am talking about a self-regulatory organization, they play a dual role. They play the role of regulator and also they represent their members. So in this case, the problem that comes out is a conflict of interest, especially in case of self-regulatory kind of organization, which acts as a regulator as well as has its own business in the same space. Those, there is a possibility that whatever the decisions or whatever the regulations they are bringing up, they might be in their own personal benefit. So some kind of conflict of interest can come into picture. So if it is a self-regulatory organization, first of all, it need not be an independent regulator. When I say independent regulator, there is a government recognition associated with it. So a self-regulatory body does not need to be an independent regulator, as well as an independent regulator need not be a self-regulatory organization. So we just need to be careful on that dimension. And as I said, if it is a self-regulatory organization which acts as a regulator, also need not be an independent regulator, but it can be a regulator, then there could be a possibility of inherent conflict of interest. So that should be taken care of by the self-regulatory organization. And as a part of the regulatory mechanism, we can even have some outside bodies like the FASB or the ICAI in India, Indian Chartered Accountants Institute of Chartered Accountants of India, or Financial Accounting Standards Board, International Accounting Standards Board. All these, they are not regulators, but they help the regulators in designing the policies, in designing the products, so that the regulators can use them and pass the regulations and contribute to the regulations more and more effectively. Right? So the typical regulatory structure may contain some government agencies or independent regulators or outside bodies. So if there are outside bodies, they just help the regulators in taking the decision by designing some policies. So they may get into policy making aspect, but they don't regulate the scenarios. Whereas when it comes to the government agencies, yes, they pass the regulations. The same thing can happen with the independent regulatory bodies also, but some of them may be SROs, where self-regulatory organizations which have their own members also with them. So there the conflict of interest need to be addressed. So when I am looking at self-regulation, especially in the context of financial markets, whenever the government does not provide any kind of a recognition, we don't call them as regulators. And as I said, most of the time this regulatory organizations, self-regulatory organizations may not be funded by the government. So, but still they may be subjected to the political pressure from the various members. But if they are more and more funded by the government, there is a possibility of more political pressure. But because they are not that much funded, they have less political pressure. They are shielded slightly from the political pressure, but still it cannot be avoided completely. And it has been observed that even if a self-regulatory organization is there, if it is properly supervised by the regulatory agencies, it has become successful in terms of implementing the objectives of the regulation quite comfortably. And historically, it has also been seen that this kind of self-regulatory organizations are more prevalent in those countries where common law is very heavily used rather than a civil law. Country like UK, US, where common law is more in place, the independent self-regulatory organizations have been quite successful. But in countries where civil law is dominating, it's very difficult to find self-regulatory organizations, and in those countries the government agencies themselves are performing the role of self-regulatory organizations. So that is one more aspect of regulations with respect to the financial markets. And why are these regulations actually required? What is the rationale behind these regulations? And what we can understand is there are two major contexts in which these regulations become more and more important. One, because of information frictions. Right? When we are saying information friction is different access to information for different kinds of people. For example, if I am talking about a private company trying to get capital, trying to raise capital from new equity investments, whatever the information a private company knows, private company has more information about its firm, the management of the private company has more information about the firm rather than outsiders. So whatever the rules and laws they pass may be more beneficial to them rather than the outsiders. So that's what I call as information friction, which generally arises because of information asymmetry. Different layers of access to information by different people for different purposes. So information is not uniformly available across non-uniform availability of the information across the various layers is what we call as information asymmetry. And the importance of the regulation is wherever the information asymmetry is there, they think there could be a possibility of unfairly treatment of the individuals, unfair treatment of the individuals who are participating in it, and regulations are more targeted towards removing this kind of unfair or inequitable distribution of information across the various participants. That is one scenario where the regulations become very important. And the second dimension where we see the regulations are very important is in the case of externalities, especially with respect to the usage of public goods, especially if we are talking about the public places or public amenities, where it is said that the government will fund those things. Any amenities like parks and all, the government would be funding those things. Every person can enjoy without causing any kind of harm or any kind of unavailability to the others. I can very well walk in a park and I can ask the others also to get into it. So it's kind of a shared resource which doesn't belong to any one single person. It's a public kind of a resource. So probably the people can use it to any extent. It's not pay-per use kind of a scenario. So those to make sure that no one is at a disadvantage in using those public goods and public utilities or public amenities, the regulations are very much important from that dimension. So generally we see these are the two major reasons where regulations can come into picture. And interesting aspect with respect to regulatory interdependencies. So generally there is a possibility that we are talking about two major groups of people when it comes to regulation. We want to look at regulators versus regulated people, right? Who are the target of regulation? Generally what we should see is these two need to be independent, but what we see is in real world there could be some kind of scenarios where there could be interdependency between these regulatory bodies. So if I look at, there are three major scenarios which I am going to look at in this case. One, I am talking about a regulatory capture theory. Let's say in this, the interesting part is, let's say we are talking about a particular company or an industry, a particular industry, right? People who are the key members in this industry, they are only there on the regulatory board. So let's say as a regulatory board, let's say I am talking about person 1, 2, 3, and it may so happen that this 1 is having one company in the same industry, 3 is a key member in one of the companies in the same industry. So if it is so happening that the regulatory body or a regulatory board is influenced heavily by the people from the industry, from the same industry, if not influenced, even controlled also in some cases, then that is a scenario of regulatory capture theory. This is where some interdependency come up, especially if the people of the companies which are representing the regulated, they are there on the part of the regulatory board also. So that causes a kind of conflict of interest, right? That kind of a mechanism where we see that the regulatory board is heavily influenced by the people from the regulated community itself, We call such kind of interdependency as regulatory capture theory. Then there is a possibility. See, generally when we look at the regulatory capture theory, typically it affects. I mean, the people who are there on the board, they may try to favor their companies at the expense of the other companies. Then, in some cases, especially if there are multiple regulatory bodies in multiple states or multiple countries, people try to take the advantage, or probably the regulatory bodies themselves will try to take the advantage because of the competition between the various regulatory bodies. They themselves will try to take the competition, or because of the competition they try to provide the most business friendly regulatory environment without too much of troubling the regulated entities, because of the competition that is existing among themselves. That's one more thing that needs to be that needs to be understood by the analyst. Then the interesting aspect is of regulatory arbitrage, especially if there are, let's say two regulatory bodies, or people try to find out, let's say if this is a regulation and there are two different jurisdictions in which the regulation is slightly different in terms of the substance or the content. So people try to take an advantage of finding the loopholes in the regulation, try to identify the ambiguities that are present in the regulation. So they try to interpret it to their own advantage. So what is written as a part of the regulation and what is interpreted out of it, people try to take the advantage out of it. And even in some cases, people try to use that regulation where it is more and more liberal, especially if there is a possibility of going with two different regulations in two different states or two different countries. And in case the regulation is more and more liberal in one country compared to the other one, people try to take an advantage by relocating into that country or a state where the regulations are more and more liberal. And in some cases, even the conflict of interest between the various objectives also. Some want emission norms to be a core objective as a part of the regulation, whereas in some case safety could be a regulatory norm. So there could be a conflict between these two, and that itself could cause the participants or the regulated companies to take an advantage of the differences that are coming between the various regulatory organizations. So to avoid all these things, it's always suggested that a global cohesion in terms of regulatory norms will try to reduce all these kind of interdependencies and try to promote much betterment in terms of the trade. Now, if at all we are looking at the regulators, what are the tools that are really available for them to provide the regulation aspect? In some cases, the regulators play very heavily with respect to taxes and subsidies. They try to tax people more, or tax some particular businesses more, or provide some tax benefits to some particular businesses as a mechanism of regulatory intervention. And same way they try to provide some subsidies so that they can promote that particular industry. So they can either hamper a particular industry or promote a particular industry through their regulatory interventions, which could be majorly in the form of taxes and subsidies. In some cases, the regulatory bodies could provide some restrictions, quotas, in terms of the amount that can be consumed or imported, or in terms of specific raw materials that could be used or banned, or they could try to provide mandatory requirement in terms of some activities to be performed. So every publicly listed company should file their annual reports and quarterly reports, some such kind of requirement of certain activities. In some cases they may prevent or restrict some activities to be performed by the companies. And the other way they can intervene is they can provide various provisions for public goods. They can offer more and more public utilities, public amenities. They can provide more and more better leisure facilities to the participant, to the public. All these kind of things, regulatory interventions can come into. And in some cases they can even get into the process of funding private projects, especially giving some kind of loans and all. But all these things, they depend heavily on the various political priorities of the companies and the objectives of the regulatory board. Political priorities and objectives of the regulators and the government. Based on this, they try to use the appropriate tools. But the major thing is, if I look at the effectiveness, all these probably there is a cost to the government. So if at all I have to look at how effective they are, I want to know how good they are implemented. Right? The implementation is a big issue with respect to the effectiveness of each of these things, because whatever the regulators have planned, they should make sure that they are implemented to the core, no violations are happening with respect to the implementations. That is what will bring the effectiveness of these interventions that are being done. And why are the commerce or the trade and the financial markets regulated? So when I am looking at the regulations in the commerce or the trade, there are so many statutes that are there, there are so many laws that are there, company law, tax law, contract law, etc., etc. The major intention behind all these things is provide a framework for the decision making. So sometimes it may facilitate some particular industries or some particular businesses. In some cases it may hinder some particular businesses. So sometimes like it can protect more and more domestic industries, so it can put some kind of regulations against the imports, or it may try to put some kind of regulations with respect to takeovers, especially if they find that this takeover is intended to create a monopoly in a particular market or a business. So the regulations in some cases, they may help a particular industry or a business, and in some cases they may hamper it quite drastically also. The same thing when we look at a regulation in a financial market, slightly it's a different thing. It always targets protect the investors' right, because most of the times in the financial markets there is a kind of agent principal problem. Shareholders are not the managers in the company. They are the owners, but they are not the managers in the company. So the intention of the financial market is always to make sure that the investors' rights are protected and the financial system is more and more stable. So they try to bring in so many things. Disclosures. On a quarterly basis, the companies have to file quarterly reports. They even have to go with the annual reports, 10Ks, 10Qs, and proxy statements have to be filed. There are so many restrictions that come with respect to the disclosures, and even with respect to how the financial statements need to be prepared. They come up with so much of details in terms of what needs to be detailed out and what need not be detailed out also. The main intentions again lie in terms of mitigating the principal agent problems and the agency conflicts, and even the intention is to protect small retail investors, so that the very large investors don't create the regulations which can benefit to their own to their own investments and benefit them on a large scale basis. So the main intention of any of the regulations should be to reduce the system wide risk altogether, which is inherent in the financial system itself. And sometimes there is a huge intervention with respect to the anti-competitive behaviors, more like in terms of merging. See, the intention is to promote good, healthy competition among the various companies. The intention of the regulation is try to promote good, healthy competition, try to remove unfair trade practices, and probably try to address some kind of monopolization of the businesses, try to provide equal opportunities, or fair opportunities to all the participants in a particular business. Keeping these things in mind, the regulations mainly try to look at any merger or a takeover that is happening which can create a kind of monopolization, excessive concentration of the market share, which can be found using Herfindahl-Hirschman index. So, which is more like taking the squares of the market share of each of the companies separately and finding out whether the value of that is greater than, let's say, 1800 or so. If it is greater than 1800, or we have few rules relating to that. Even if it is greater than 1000, if there is a change by at least 100 with respect to the takeover, then an antitrust law can very well come into picture, and probably the regulation can stop that merger from happening. Even if some kind of a discriminatory pricing is being done, some people are priced very heavily, whereas some clients are priced very low. All these kind of discriminations can very well be either promoted or hampered. Probably they may say, for the poor, this particular article cannot cost more than this particular amount, whereas for the remaining, it could be priced at a normal price. So they could create a discriminatory pricing. They could stop the discriminatory pricing also, depending on the necessity and the intended objective of that regulation. Similarly, bundling of the products, they can even get into exclusive dealings, probably giving some kind of favoritism or prioritization in terms of some contracts to some specific companies. So these kind of things are excessively investigated by the regulators, and their intention is to make sure that there is enough handling or enough uniformity in handling these kind of activities across the various companies. Then when we are looking at the regulation from a company's perspective, obviously there is a burden, because every company has to comply with that regulatory aspect. So there is a cost of compliance which is called as a regulatory burden. But at the same time, because of regulation, there are some benefits also that are being received. So if I remove the private benefits that are going to be received, we call that particular modified burden, whatever is the cost minus whatever are the private perceived benefits that are going to be received out of the regulation, we call that as net regulatory burden. But in this, even the indirect costs, right, not just the implementation costs, even the indirect costs also need to be taken into consideration. But arriving at the various indirect costs upfront, indirect cost is whatever is the cost that could be that could be arising even in future also, or some kind of unintended consequences that may come up in future also. Some kind of assessment of those things have to be done, and they have to be figured out in the cost, but it becomes very difficult to find out all those indirect costs. So whatever is the net regulatory burden that is coming out may or may not be an appropriate measure, because there is a lot of difficulty, because the economic behavior can keep changing with time. And in some cases we also see that many of the regulatory provisions, they have some kind of a sunset clause, which simply says if at all you are trying to modify the regulation, observe the reality, see what are the actual outcomes, look at the cost versus benefit analysis out of the actual outcomes, actual versus the estimated, look at the cost versus benefit analysis, perform a thorough evaluation of the same before actually getting into the revision, or before actually renewing of the regulatory contract. So that's one more thing that is suggested. And when we talk about the regulation, what we see is it is going to impact a few industries very badly, whereas it may not impact a few industries at all, depending on the kind of regulation. It may impact industry in general, and probably a few companies in more particular also. Or there could be some kind of regulations can have similar kind of impact across all the companies in the industry, whereas a few regulations, they may impact some companies very heavily but not the other companies, and a few industries could be impacted more heavily compared to others. And from an analyst dimension, all these are very much important, because when he is trying to do an industry analysis or an industry valuation, or to assess the industry growth, and in particular company valuation, which will impact the sales and the cost of goods sold and all other entities of the financial statements in future. So as an analyst, as a financial analyst, the focus should be on the probable impact of these various regulations on the financial statement, especially if the regulator, who is a kind of SRO, self-regulated organization, who is a regulator, as well as who also has a regulated, then there is a high possibility for those kind of companies, whatever the regulation is coming up, it is trying to benefit the underlying regulated entities at the cost of the others. There is a heavy possibility, and at the same time it is seen that on a whole these regulations can introduce more and more inefficiencies also into the system, because if it is known that even if I don't perform well, the government will bail me out, that introduces a lack of risk management in the process. So sometimes inefficiency in the system can very well be introduced because of the various regulatory aspects, and in some cases we could see some specific sectors can get badly impacted compared to the others. So these are the various things that we need to look at when we are talking about regulation. Primarily, what is the basis of this regulation, why is regulation typically needed, and in what ways regulations can come up, what are the kind of interdependencies that are existing, and finally talking about the costs versus benefits associated with this regulation. I hope you are able to understand the basic intention behind all this concept of regulation. Any further queries you have on this, you can very well get back to me by giving me a call on the number that I have provided below, or you can even send in an email at vamsidhar@pacegurus.com. Thanks a lot for listening to this session. Thank you very much.